38 of 2026.
Was not placed. Anyhow, I was not in a position.
Disposing of the page 68, the text we use. No, whatever. Tell me the
Annexure number 8.
This is 18/7/2025 order.
My lord.
No.
60.
Sir, relevant portion.
Yes, let
These two judgments of Justice Particular in 1964 Supreme Court has been relied.
judgment,
2008 A submission.
Yes.
But they have said that a clean application is maintained in a disposed clean application. For implementation of the order.
What is this?
For SCC online, Indian hard copy.
A and study.
What?
Just particular judgment and given one second.
Earlier was not. Where they have said that an Indian application should be. Or implementation is maintained.
If you see, if you have cited a judgment, we feel it our duty to
No.
rely on those judgments.
There's one thing I wanted to say, members, the IA filed by them was for implementation of the order. End block, the prayer is implement the original order. Now, implementation would also include reconsideration of in terms of 1156, which says that whether the meeting has been conducted or not. In this process, my lord, the state has completely rewritten 115. There is no findings even today that he has conducted that meeting. If the state comes up with a reconsideration and says that yes, those meetings were conducted, then I am out of court. I have no case.
Let us listen.
That's my basic.
Uh,
Next week,
Whatever letter you just. Right.
Supplementary list item number 2.
Just. Discussing of. And the position and I've challenged the point.
my lords, if I may,
Yes, municipal corporation, 3 and 4, representatives.
3 and 4.
Representative.
I'm on behalf of 3 and 4.
4.
3 and 4. Yes, ma'am.
Why you did not appear yesterday?
My lords, we had no instructions to appear there. Yes, ma'am.
Now you have got.
Yes, my lords. Yesterday night we received the copy, and so we will be filing the wakalatnama during the course of the day. My lords, may kindly grant us some time for instructions to be taken.
Come tomorrow, take instruction. We are giving you a time because it has been given to you yesterday night.
My lords,
Take instruction. Yes, for
Another list. Special weekly daily list. Item number 1.
73-4B matter of you. This is 73-4B matter. Sorry,
you should not appear.
I should not appear, but unfortunately,
Why you are appearing?
I'm only appearing on behalf of Mr. Jenna, who is not well. And he's a friend of mine, Lord, he has requested. That's why I've not also mentioned my name, Lord.
These are all the food for the juniors.
It's not the food part of
Food
it.
for the juniors.
No, it's not a food for me, Lord. It's only
Not food for you.
not a food for me.
Your name will be recorded, but not.
Well, need not be because Mr. Jenna is appearing. I've made the necessary corrections. He fell ill, that's why, Lord, he requested one. I'm sorry, Lord.
Item number 2.
You are not writer, sir.
Maya.
Item 2.
This is
RC cancellation.
nobody is very much vigilant in pursuing his matter. Mentioning everybody will come. When the matter is listed, nobody will come. Give RC.
Yes, ma'am. Item number 3.
3 minutes GST RC.
RC cancellation.
Yeah.
Item number 4.
Or
RC cancellation minutes.
Item number 5.
5 is also RC cancellation.
Item number 6.
matters.
4 was not mine. 4 was on behalf of Miss Jana Switis.
5, 6.
6.
Your lordship, RC cancellation.
4 am there, your lordship.
Item number 7.
7 minutes RC cancellation. 8 minutes.
Item 8.
8 minutes.
RC
Your
cancellation.
lordship, I'm there. My video was not coming on, so.
She was for 4.
Finish.
Item 4.
Oh,
This is 8. 8 of this.
RC cancellation, I have given you off.
Yes.
Item number 9.
RC cancellation.
9 लिखा है जो कर देखो. Item number 10.
This matter relates to section 73.
When the Supreme Court has fixed the matter.
Matter is tentatively listed.
When it is.
Today is the-
Today, okay.
That's a tentative list.
Yeah,
That's a tentative list, probably to be listed.
Okay.
Item 11.
11 RC cancellation.
Well, let's see, 11 and 12 both are RC cancellation matters.
12.
Yes.
Item number 13.
Second also RC cancellation.
Wait, Mr. Dilip Kumar Sahu is not appearing, I find.
My lord, he was here few minutes.
Next.
Item 14.
RC cancellation.
Item number 15.
Yes. Well,
Weekly list item number 1. WPC 9617 of 2023.
you are appearing in, Mr. Das, you are appearing in 2. And who is appearing? What do you want?
Yeah, regarding construction of the road, your lordship has directed to file an affidavit with respect to the development that is being taken by the government. In the meantime, my lord, all valuation report regarding acquisition of the land, everything has been received. It has been sent to the government. So the further reports and final affidavits will be filed, take this on board.
So you wanted an extension of time to file report.
But
How much?
2 weeks I would pray, but in any case, because of since the land.
2 weeks will expire during the vacation. Do it on the reopening?
On the roof.
On the reopening?
But by that time, file.
Do it. Just on the reopening. Extension of time to file affidavit. Sorry, this was one small imbue. Yes. Forgot everything.
Only one small,
Forgot everything.
you have not asked me to make that 2 pages, I made it in 3 pages. That's the only small in that. Just give it to me. And also what I have done is got the list of dates. The
That's
same.
the non-adherence of the court's order.
Yes, so what I have done is the.
So you admit non-adherence of the court's order.
No. Only by 50%.
Can you recapitulate?
If your lordship will have this, it will be 3 pages will be sufficient to recapitulate. Your lordship will see.
Oh. No, I got you. I got you.
It will be.
The first line reminded me everything.
Yes, obviously so.
Yes.
So what I've done is what I've given this list on it, and this has the same thing identical. Only thing is what I've given where it is, in which paper book it is, with the date, so that your lordship had last time having wonderful difficulty. So the change in this, it is exactly only one small thing what I want to do. I have not argued that. I just 5 minutes I take on that. Rule 45 is the used for some time, because of which I came to the court, saying that auction price will be the base price will be the Rule 45 price. Now, if your lordship will just kindly have the constitution first, the Constitution of India. I'm sure your lordship knows this very well, but just I want to just re-emphasize this. Entry 154 and entry 223. Of the 7th schedule.
State list or a union list
So union list is list 154.
union list is
154. List 1, item number 54.
is
Regulation of mines and mineral development to the extent to which such regulation and development under the control of the union is declared by parliament by law to be expedient in the public interest. Now please see entry 23 of list 2. Regulation of mines and mineral development subject to the provisions of list 1 with respect to regulation and development under control of the union. Now, Lord, what they declared in the Act, if your lordship will see section 2 of the MMRD Act. Everything else remained with the state. It is hereby declared. Section 2.
yes.
It is hereby declared that it is expedient in the public interest that union should take over under its control the regulation of mines and development of mineral to the extent hereinafter.
That is
provided.
because of that. And
Yes. Now, Lord, this declaration only limits it to this, and that is why, if your lordship will see in the entire Act, there is no rule making power with regard to merchant sale of any mineral. What is there is only with regard to how mine auction is to be done. So that is why the central government brought in that other writ petition clarified that Rule 45 is only for the purposes of determining the value of the quantity of mineral in a particular mine for the purposes of taking a quotation or for the purposes of finding out the eligibility to participate in the auction. So Rule 45 was only for that limited purpose. And only 2 judgments brought which only for the limited purpose that if the Parent Act does not provide for something, then the rule cannot extend beyond what was there, because although we don't need to go that far, but central government itself has said in its affidavit that this rule is not for the purpose of merchant sale of minerals. So 45 was misapplied, because of which I came to the court, and then on the basis of 45 they started making these fanciful demands that 4,000 crore, etc. That is why I came with the amended writ petition. Your lordship permitted me to make the writ petition. And kindly see section 13 of the MMDR. I have also brought section 13, the rule making power. Rule 45 is under 13.
Yes. Which clause?
13 is the
Subsection 2, which clause?
Yes, so let me go by for central government may by notification in the official and make rules for regulating the ground in respect of minerals. In particular and without prejudice to the generality of the following part, such rules may provide for all or any of the following matters. And Lord, the price is not mentioned in any one of them. Merchant sale price is not mentioned in any one of them. The central government may by notification in the official guidance make rules for regulating the grant of mineral concession in respect of mineral and purpose connected therein. So grant of mineral concession is the only scope of these 13. And then everything which is there in the sub clauses of 13 are only dealing with that part only. In fact, there are two rules which talk of manner of sale of mineral, but that is also just for captive mine. Just see that also. S&T. Manner of sale of mineral by the holder of a mining lease under subsection 5 of 8 and T.
Which one?
Manner of sale of mineral under 7A.
Which one?
13(2)(s). 13(2)(s). I'm so sorry. The manner of sale of mineral by the holder of a mining lease under subsection 5 of section 8 and the manner of sale of mineral under subsection 7A of 8A. These are both, firstly, only dealing with manner of sale of mineral, and number two, they are dealing with captive mines. That if there is a captive mine and you want to sell beyond what you utilize, then that manner is to be decided under this. So that's all that is. So that is all what I wanted to just add this.
What is the definition of a minor concession, mineral concession?
Mineral concession is also, yes. My friend actually wanted me to show that. He's exactly, yes. Mineral concession means either a recognized permit, prospecting license, mining lease, composite license, exploration license, or a combination of any of these, and the expression concession shall be considered accordingly. So
it's too wider and encompasses.
I appreciate it could have been, but since it's controlled by the union, and only to the extent it will be controlled, so it can't be read widely, because otherwise then state can't fix the price at all. If the price fixing power was vested in this act to the center, then the state can't fix the price at all.
No, that is true, but it is in tune with that particular entry one, a list one. It's subject to list one.
So list one,
if the central government has already fixed the modalities or the mechanism of ascertaining, then in that event one has to understand that it is.
But fortunately for us, the central government itself has clarified on affidavit to this court that this rule is not meant for the purpose of merchant sale of the mineral. And even when they started selling me the mineral in 18, they themselves didn't apply Rule 45. They applied it in 19, and then again in the latest policy, they don't apply Rule 45. So it's not something where there is much of on legality is much of a dispute, because central government, supposing central government had said that we have actually taken over the price fixation also for merchant sale of mine, then your lordship would be dealing with this proposition. But the central government on affidavit says that I am not dealing with merchant sale. I am only dealing with the price for the purposes of recognized, which is referred to let us hear. And just see while your lordships are in the act, just see Lord 8.5 also. 8.5 of the lordship which is guided here. Manner of sale of mineral in what cases?
Is a captive purpose.
Yes, where it is captive.
So it is given, any lessee may coal lignite used for captive purpose.
Yes, such coal or lignite. So this is only coal or lignite. We are concerned with actually 8A, 7A, 8 capital A, 7A. That is only coal or lignite.
That is also captive.
So yes, that is also. So any lessee may, where mineral is used for captive purposes, sell mineral up to 50% of such the total of mineral produced in a year, after meeting the requirement of the end-use plant linked with the mine and such, and in such.
Anyhow, your case is rested upon a promissory estoppel.
That's right.
Primarily, let us see.
Yes, so I really, these are not relevant, but they will argue all this. So I thought let us just.
There are the things to be gone into what he says about it.
Yes, that's fine. Very deeply over it.
Vedanta, the petition before my lords, has lords based its case entirely on the principle of promissory estoppel.
True, yes.
But the issue, interestingly, the issue with regard to promissory estoppel, was not raised, my lords. Not only in this writ petition, the issue with regard to promissory estoppel or the ground of promissory estoppel was not raised by the petitioner, not only in this writ petition initially, but also in the earlier 3 writ petitions filed before my lords with regard to same subject matters. There was never, my lord, this plea of promissory estoppel raised at any stage. It was for the first time during the arguments, when the argument started before my lords. For the first time during the course of arguments, a prayer was made for permission to amend the writ petition to incorporate the plea of promissory estoppel. And my lord thereafter granted permission to file an application for amendment, which was ultimately allowed. So that's how the plea has been introduced. But may I just show
why you are taking that plea? Are you trying to take shelter under, I think, explanation 4 or 6 of section 11 or order 2 rule 2 of the court? What?
No, it's not that. It's an afterthought. It was never their case. I have my the main submission will be, it does not apply in this case at all. The principle of promissory estoppel does not apply at all. But even the petitioner thought from the beginning that does not apply. Otherwise, there was no reason why in all the writ petitions filed by them till now, that issue was never raised. It was only when the hearing started this
reprobate cannot happen.
My lord, sir. But I have not made a convenience compilation where I have I just pass on the copies so that my lord don't have to go here and there. All this from the record only. I have mentioned in relevant pages. But some pages are not legible, so we have changed it and not added it at the appropriate place. But it may not be very neat, not in that sense. Kindly first see, the first writ petition was writ petition 9926 of 2020.
Where?
That my lord will find at page 103 of the compilation. At 105. This is the first writ petition 5 before my lord.
Yes. Of 2 pages.
With regard to this is only the prayer I have not quoted here.
Okay.
No, I got it.
Yes.
It's only to show that
just prayer. What they have said.
My lord, only to show that they have no prayer with regard to promissory estoppel.
Yes.
But page 105, only the prayer will I read. It is therefore prayed that this honorable court would graciously be pleased to issue a writ in the nature of mandamus, directing the opposite party to conduct national e-auction for sale of bauxite in accordance with the notification of Government of Orissa, Device Seal and Mine dated 24/2/2018 by the annexure 1. That was the only prayer made. But thereafter, I'm not in the, my lord can take my statement that in the writ petition, it is on record. There was no averment with regard to promissory estoppel at all, or any ground with regard to promissory estoppel. Then the second writ petition is 22397 of 2020, but immediately after it, page 108 of the compilation. The prayers are at page 109.
Right. First writ petition. Give it to me.
The prayer is at page 109 and 110.
Page 108.
108, the writ petition starts.
Is the second writ petition.
It is the prayer that page
the second writ petition.
110.
Write down second writ petition. First writ petition.
Second writ. This was second writ petition.
First WP, second WP. Yes.
But first writ petition, I have placed one. This is second writ petition. But there were 3 writ petitions filed before this.
Give me first.
This is fourth writ petition now.
Now, second is at page 108.
My lords. Okay. Prayer is at page 109.
Yes.
Allow the present petition.
Right, third.
If a rule nisi in the nature of statutory and or a rate in the nature of mandamus and or any other appropriate rate order or direction, quashing the national e-auction tender notice dated so and so, corrected on so and so, and holding the said action to be in violation of the notification dated so 24/2018 of the state government, as well as sales agreement dated 20th April 18, that will amendment agreement dated so and so, and the long-term LTL is long-term linkage policy dated 10/7/19, and directing opposite party number 1 to conduct the next successful national e-auction of bauxite strictly in accordance with the notification dated 24/2/18, that with sales agreement dated 20th April 18, an amendment agreement dated 27th March 19, and LTLI policy dated so and so. Then on the next page, issue a rule nisi in the nature of statutory and or a rate in the nature of mandamus and or any other appropriate rate or direction or order. In national e-auction of bauxite, fourth auction held so and so, and holding it to be completely arbitrary and unreasonably and manifestly unjustified, and in the teeth of notification dated 24/2/18, that with sales agreement dated 20th March 18, an amendment agreement dated 27th March 19, and then into between OMC, Orissa Mining Corporation, and Vedanta. My lord. Then what the fees. But this was the policy, this is a policy notification issued by the government. Pursuant to which the auctions were being held. The policy was being changed from time to time.
The policy, not here, nobody. 19 means LTL policy.
So similarly, next prayer also is on the same lines.
But what?
But the next prayer in that page 110. My lord is seen it, not. I do not wish to repeat it. Question decision of the party not allowing the federation to lift the bauxite to be illegal and unconstitutional, fourthly to issue the allotment order, etc. Then one more petition was filed, that was at page 112. The prayer is at page 116. This is not where the violation of Rule 45 is challenged.
The present situation.
Page 116 is the prayers. Admit the representative application, declare the amended Rule 45 as validity of Section 13 of Mines and Minerals Development Regulation Act. Declare that the amended rule does not apply to e-auctions of bauxite for determining the floor price.
Here, they wanted to enforce it. What there?
My lords. Declare that my lord is right. The floor price of the e-auction for the national auction is to be determined by calculating the cost of production plus margin profit 50%. As contemplated in clause 4 of the agreement dated 20th April 2020, as amended on 27th March 19, read with the long-term linkage policy dated 24/2/18. No, that is the policy enforced at that time. And etc. etc. All this I will not place before my lord to show that there was never any prayer made or ground raised with regard to promissory estoppel in all the writ petitions. But in the present date petition also, kindly now come to the prayers in the present date petition. 160. Page 160 of this, I have expected it in 60. My lord. But this is the amended prayers after the amendment was allowed by my lord. Page 160. My lord. Notwithstanding any prayer, my lord, there because the original one was not very legible. So we have given it separately also. It is there in the file. But it was actually that the page was not legible. That's why we have given it separately also. Notwithstanding any prayer already made, but this is after the amendment was allowed by my lords. Notwithstanding any prayer already made in the writ petition, issued an appropriate order of direction to the OMC and Government of Orissa to provide minimum 150 million tons bauxite at a price spelled out in the agreement of 2004 and 2009. That is now, Lord, they go back for the first time by way of amendment. This is not brought in. Those agreements, Lord, which have come to an end, Lord, long since, should never, Lord, thereafter, Lord, referred to, acted upon, or relied upon, or any right was claimed on those agreements. Read with Memorandum of Understanding dated 7/6/2003 and 4/4/2007, the supplies of approximately 20 million tons, very interesting, the supplies of approximately 20 million tons of bauxite already made to the petitioner since 2018 be deducted from the said 150 million tons bauxite. This is the kind of prayer which is made after the amendment is allowed. You can see next prayer also. In 2025, they make this prayer. For Lord got that supply at the price of the 2000 MOUs of 2004 and 2009, and Lord to give the balance now because the price there would have been much less at that time. And also the JV agreement, Lord, the Reliance joint venture agreement also, which which could not be implemented by virtue of operation of law, and ultimately terminated. We kindly see next prayer. Now, these two are added by the amendment. Notwithstanding any prayer already made in the writ petition, issue an appropriate writ order or direction commanding the state of Orissa to adjust the supplies made so far of bauxite at the rates specified in the agreement of 2004 and the surplus amount coming into the hands of OMC on that basis be utilized for further supply of bauxite. All this was never raised at any stage. For the first time it is brought in by way of this amendment. On the basis of the principle of promissory estoppel. But kindly look at the time when it is raised. The 2004-2009 agreements, which had ceased to exist, they were for a limited period. There were two MOUs. JV agreement was also terminated and also became impermissible as per law by virtue of amendment of the MMDR Act, Section 17 AC. So, that relief is sought to be introduced by way of my lords, this amendment. Then the rest, of course, my lord, these were the two prayers which were added by after my lords allowed the amendment. Now, my lords, thereafter, my lord, the amended petition was filed, as my lord remember. But I had, and we had raised certain objections. They have with the reply to the rejoinder. They have replied to the additional counter. They have added certain facts which were disallowed by my lord. The amendment that is a separate issue. I will deal with that at the end only. I do not raise it now. I will not mention that after we have filed the expunction application, that those facts in support of promissory estoppel, which they had pleaded in the application of amendment, but which my lords had not allowed to be taken on record, cannot be taken on record for the purpose of the my lord deciding the issue of promissory estoppel. That, my lord, I will not make my submission later on. So, my lord, all this clearly shows that this is, my lord, an afterthought. Please barred by limitation for which no explanation has been given, the plea of promissory estoppel. And Lord, there is also the well-settled legal position that the promissory estoppel cannot be claimed against the law. I will demonstrate that, my lords are well aware. These are settled principles. I will not show from the record how it is against the law what they are claiming now. In the present case, I am just giving the brief of this. After I will come to the list of dates and other. In the present case, the obligation under the MOUs of 2003 and 2007 with regard to grant of bauxite mining lease would not be implemented in the absence of environment clearance. Those were two MOUs were entered into. But the environment clearance, forest clearance was not granted. in spite of all efforts made by the state of Orissa, Orissa Mining Corporation, as well as Vedanta, up to the Honorable Supreme Court. Several rounds, several litigations were there up to Honorable Supreme Court. Ultimately, forest clearance and environment clearance were not granted. As a result of it, the bauxite mining lease could not be granted. So, the basis of those MOUs and the JV agreement could not be implemented because the forest clearance and not the environment clearance for grant of bauxite mining lease was not granted. So, the submission also is that the doctrine of promissory estoppel cannot be invoked for enforcement of a promise, which becomes impossible to perform because of operation of law. Then the other argument is, which I am going to not ultimately elaborate. I am just summarizing my submission. In view of the execution of LTL sales agreement of 20th April 2018, and there were LTL long-term supply, long-term linkage agreement they had entered into with the Orissa Mining Corporation. And acceptance of bauxite pursuant to those agreements. Now, Vedanta cannot now claim specific performance, having availed of benefit of those LTL agreements which they had entered into after those MOUs ceased to exist and after the LTL agreement was terminated.
GB agreement.
Those which is valid terminated on the principle of estoppel, they can now claim relief on the basis of those agreements in 2025. That is the submission. But from the record of the case, we will demonstrate that principle of promissory estoppel is not applicable to the present case. But I will not immediately come to the list of dates after this. The last thing, my lords, my friend repeatedly stated that, my lords, the Vedanta has spent 1 lakh crores. It is invested. Well, I have no reason to doubt that. But in all fairness, my friend perhaps should also have stated they have put up aluminum smelter, they have put up a refinery, they have put a power plant, they must have spent the money, there is no dispute. But my friend would also perhaps should have also pointed out that how much profit they have made from their investment. Beside this, the investment they have made, there is no doubt they have done. But they have also made profits. That is not a business proposition. So investment is something which we are grateful, we are grateful to them, they have made. But then that is also a business proposition. Now I will pass on the list of dates.
Can there be any investment without expectation of?
No, that's what I am saying. But that is submission. That is submission. That but if you have invested, you have invested for purpose of business. May I just pass on the list of dates and will not refer to the various documents from that 2004 or the MOUs of 2003 and 9 and show how those have ceased to exist. Kindly pass on and give the copy to the other side. But along with the list of dates, I will place the relevant folder portions of those documents. Kindly turn to the list of dates. From 7/6/2003, this is the first MOU, this is the beginning. MOU was executed between Government of Orissa and Sterlite Industries Limited for setting up an aluminium refinery complex at Lanjigarh, district Kalahandi. This kindly turn to the compilation, page 1 and 2. But the second recital. Now, first is whereas Sterlite India Limited is desirous, my lord got it? Page 1, my lord, the compilation. Whereas Sterlite India Limited is desirous of setting up an aluminium refinery complex at Lanjigarh, Kalahandi district in Orissa state, which would include setting up a 1 million ton per annum aluminium refinery, 3 million ton per annum bauxite mining facilities, as well as installation of a captive power plant and appropriate investment of approximately 4,000 crore. And whereas the Government of Orissa agrees to provide all help, prevailing incentives, and facilitate clearances necessary for the aforesaid project in the state of Orissa consistent with the constitutional and statutory provisions relating to the area of the project. This is what is important, my lords. Consistent with the various constitutional and statutory provisions relating to the area of the said project. Then, my lords, page 3, kindly go to page 3, my lords, capital B, raw material. The Orissa Mining Corporation will take necessary steps in executing an agreement with Sterlite India Limited with the approval of the Government of Orissa, Institute Mines Department for all matters relating to the bauxite mining lease. The transfer of mining lease from OMC to Sterlite India would be considered only after the Sterlite India has made substantial physical and financial progress towards implementation of the project to the satisfaction of the state government. Then page 5 and 6.
But the changing law, no mining which I granted to, because the changing law, no mining they are granted from, so that was my question of transfer.
But it's only a change in law that mining law is not granted ultimately. That will come in the facts, but I will not place when it comes. Kindly go to G. Subclause D at page 6, my lords.
Duration of the MOU.
My lords.
2 years.
My lords.
On the date of signing.
My lords. The MOU shall remain valid for a period of 2 years from the date of signing. Further extension, if necessary, shall be made as per mutual agreement, etc.
2nd of June 2000.
My lords. I'm not at the G also at the bottom. In the event of non-implementation of the project as per part thereof, the corresponding support obligation of the Government of Orissa indicated in the MOU.
Giving provision.
My lords. My lords.
Of all incentives.
My lords. Then we want to kindly tell me next MOU at page, my lords, 8.
Paid for the list. Both from the list of.
But the next list, okay, next date in the list of dates kindly see. But 5/10/2004. My lords, this is JV agreement between OMC and Vedanta to set up a joint venture company in order to operate the Lanjigad mines and Karlapat mines. But this is for the specific purpose to operate Lanjigad mines and Karlapat mines. Kindly return to page 9 of the.
Yes.
But the preamble at the top, whereas OMC has applied to Government of Orissa for separate mining leases under the provisions of the Appropriate Act and rules in respect of the Lanjigad mines and the Karlapat mines as defined here and after. Vedanta intends to set up an integrated aluminium complex in Orissa with an aluminium refinery of about 1 million tons per year capacity.
It says that he wanted to exploit or new else.
My lords.
So GBA was.
My lords.
As a joint venture.
My lords.
And then.
My lords.
This was the decision.
My lords.
The agreement was entered into.
My lords.
October.
My lords.
2004.
My lords.
At this time, the Sterlite has gone.
My lords. Vedanta had come in place of Sterlite.
Yes.
So it was only this I was reading, but it is confined to those two mines, Karlapat and this Lanjigad. Then what C is D. D kindly see. It is also the intention of the parties that the bauxite mined from the mines be sold to by OMC to Vedanta on the principal terms, conditions hereinafter set forth. I'll also read C, maybe a little relevant. Let me read C also. To help set up such aluminium complex in Orissa, OMC was.
Yes, it's agreed to.
In order to operate the Lanjigad mines and the Karlapat mines, the party agreed to set up a joint venture company with JVC on the principal terms and conditions they are here now to set forth. Then, my lords, page 11 or before that page 10, there were definitive agreements, shall mean the agreement so and so. Shareholders agreement, shareholder and subsidiary agreement between OMC and Vedanta. So this is little relevant for the reason, my lord.
Three types of agreements.
My lord, my lord.
One is the shareholders or a share subscription agreement with
My lords,
OMC.
My lord.
It's a leasing contract.
my lord. Long-term purchase agreement. My lord. Then the mines are specified at the bottom and Karlapata end. But these are mine specific agreement, or is what I want to show. That these are really these two mines. And kindly turn over the next page is the mines are described, that I did not spend time on, take my lord's time on that. The period of mining preparation, etc., raising cost, etc. Then my lord, the page 11, my lord, is that page 11 is the mines. Then my lord, kindly see. Page 11, the period of mining operation, my lord, the see.
Stays under the structure and ownership or whatever.
My lord, my lord. But page 12,
Or any other mine.
page 11, my friend wants me to upload the second para. Mine shall mean the Karlapat mines and Ranjigarh mines. That my lord has noticed. My lords.
Last word is collectively.
And collectively. So these two mines collectively.
Karlapat का क्या हुआ? It's not. It's no.
Then can you turn to page 12? The page 12, article 2. Article 2. The parties hereby agree to approach the government of Orissa for expediting the grant of mining leases in favor of OMC in respect of Ranjigarh mines and Karlapat mines. In the event of mining lease, it is not granted to the government for the Karlapat mine. Any other bauxite mine having at least an equal quantity of bauxite deposits, subject to having at least a complete quantity of 150 million tons, when taken along with Ranjigarh mine, shall be made available by OMC with due approval of the government of Orissa, government of India, government of Orissa, and all references contained herein in respect of the Karlapat mines shall apply mutatis mutandis to such other substituted mine or mines as and when Vedanta proceeds to set up the integrated aluminium smelter in the state of Orissa. Then definitive agreements. Kindly see the first sentence is important. Subject to mining lease for the Ranjigarh mines. Subject to obtaining the mining lease for Ranjigarh mine. But this was the condition, which never could be fulfilled. The parties hereby agree to enter into definitive agreements which shall contain the following key provisions. Shareholders and shareholder subsidiary agreement between OMC, Vedanta and in relation to JVC, that is joint venture company, shall provide the following. Parties agree to incorporate the JVC as a private limited company. Kindly return to this 2 is very important at page 13. This is very crucial because this ultimately means.
But by virtue of it having brought subsequently,
My lords.
when the situation becomes reversed,
My lords.
where you should have 74% of the shareholding,
I'm grateful, my
and
lords.
they should have a 626,
My lords.
which here is just top of
My lords. So this became impossible of performance. That's why I was not pointing out this. This agreement became impossible of performance because of the amendment which came in the meantime, while the process of this obtaining mine is going on.
Sure.
Because as I said, this went up to the Honorable Supreme Court several times. While the process was going on, this amendment came. So this became inoperable because of the amendment, the intervention of the amendment of the MMDR Act. No, I did not read, my lords seen it. I did not read this. My lords have already seen this. So the board, JVC will be managed by a board of directors comprising of 6 directors of Vedanta, Roman 3, my lords, 2 of which shall be nominee of OMC, who shall be part-time directors not involved in the day-to-day operational running of the JVC, and the remaining 4 shall be nominees of Vedanta. It is clarified that chairman and managing director shall be chosen from among Vedanta nominees. Management control and over the day-to-day operation of JVC shall be vested solely with Vedanta. And right of first refusal, neither party shall have right to so and so. Then 2.3.2, kindly see. The raising contract agreement between JVC and OMC for and in relation to the mines. When mines will mean those two mines, Marot, Kadlapat and Lanjigarh, shall contain the following key provisions. JVC shall be appointed as the sole raising contractor to exploit, develop, operate and maintain the said mines. It is expressly understood that OMC will not engage any raising contractor other than JVC, the said mines, to raise bauxite. OMC shall reimburse the raising cost to the JVC. OMC shall be responsible for payment of all taxes and dues, etc., etc. Then you can turn over the page. OMC agrees to appoint, at page 14, JVC as the raising contractor in respect to Lanjigarh mines for exploration and development of mines. The JVC shall carry on exploration, etc., etc. I will not remember. I will skip over all these provisions. F, if I may read F, some portions. OMC shall allow JVC to operate the mines as raising contractor in respect to Lanjigarh mines without any letter of interest, subject to the following terms and conditions on execution of the mining lease. OMC will continue to be lessee in respect of the mines to be operated by so and so. Authority grant in favor of JVC to operate the mine for the so and so, with the life of the mining lease, etc., is renewable after expiry set period. Then Roman 4. If for non-performance and discharge of the above stated obligation on JVC, as are enumerated in subclause so, any liability accrues or devolves on OMC, it is specifically understood and agreed by the party, the JVC will only compensate. Then the JVC agrees to provide all information, etc. And that my lord may. 2.3.3, kindly go to page 16. But this is very important. Kindly just see 2.3.3. Yeah. The long-term purchase agreement between Vedanta and OMC for purchase of bauxite mined from the mines shall contain the following key provisions. The bauxite raised by JVC shall be purchased by Vedanta. But kindly mark the words, the bauxite raised by JVC. So the bauxite also be raised by JVC, not by OMC. Shall be purchased by Vedanta from those two mines by Vedanta by paying OMC an amount which will comprise raising cost, a sum of money calculated in accordance with the subparagraph B below, and 3, royalty payable to government of Orissa, and 4, any other statutory dues payable to the state government, central government, and any other constitutional and statutory bodies. Then next is, in the event and on the issue up to the time that only the refinery is operating, Vedanta shall pay to OMC an amount equal to royalty at prevailing rate for every ton of bauxite, etc. This is a pricing mechanism. So this, the implementation of this is being sought in 2025, and this situation completely changed. JVC could not come into existence. The supply was not to be by the JVC on these terms. At this price, the supply was to be made by the JVC, which never came into existence. So no investment is made in those two mines because mines could not be granted, and this agreement became impossible to performance because of the amendment of the Act. Then kindly go to now 5/10/2004. Can you do the list of dates? 5th October 2004. Government of Orissa communicated its decision to OMC to containing terms and conditions for grant of mining lease for bauxite over an area of 721 hectares in village Lanjigarh and district of Kalarni and Rayagada. Clause so and so of the expected grant order accepted below. But that is not very relevant. You can go to the next page. That is important at the top.
Both the FC and the EC has to be obtained.
That's what I wanted to show. Then 28 February 25. Government of Orissa forwarded the proposal of OMC for diversion of 660 hectares of forest land for mining of bauxite over Lanjigarh mines in Kalahandi and Rayagada district to MOEF, Ministry of Environment Forest. But thereafter, 2005, an IE was filed by Vedanta because all these, the Honorable Supreme Court was seized of all these matters at that time. My Lord must be aware. Yeah, IE was filed by Vedanta before our Supreme Court interpreted seeking a direction to the MOEF to take a decision on the forest clearance proposal.
Forest clearance.
My Lord.
Yeah, property bound to honor that promise.
By 28 to 25, 2005. On 4/4/2007, Lord, an MOU was executed between Government of Orissa and Vedanta for setting up an integrated aluminium complex at Lanjigarh in Kalahandi district. Clause 2.4 provides that the MOU shall remain valid for 2 years from the date of signing, and further extension, if necessary, shall be made as per mutual agreement. This, my Lord, will find at page 24 of the compilation. I will only read, my Lord, the two paras. Page 24, my Lord. But page 24 is the preamble, whereas in the middle of the page 24. Whereas Sterlite Industry Limited has signed a memorandum of understanding with Governor of Orissa on 7th June 2003 to set up a 1 million ton aluminium refinery complex. And whereas Sterlite has formed a subsidiary company in Vedanta Aluminium Limited, and whereas the work done by SEAL will be deemed to have been done by Vedanta, whereas then execution of the MOU entered into today's government, whereas on execution of this MOU, the MOU entered into between Sterlite and State of Orissa on 7th June will be deemed to be not in force. And whereas WAL is implementing the said aluminium refinery complex, etc., etc., but the rest is not relevant. Then on page 28, clause Roman 4. The validity of the MOU. What is dated 4/4/2007? The MOU shall remain valid for a period of 2 years from the date of signing. Further extension necessary shall be made as per mutual agreement. However, no such extension shall be considered unless Vedanta has made substantial progress on implementation of the project in terms of production and erection of plant and machinery, etc., etc. Then, my Lord, kindly go to the list of dates. Proceeding number 7. 23rd November 2007, in IA number so and so, filed by Vedanta in petition number so and so, but there is a TN famous TN Godavarman case. Petition number 202, which is still not continuing. Various IAs are filed, even now filed in that case for this various this clearance, etc. While declining to grant clearance for the project, Honorable Supreme Court granted the liberty to Sterlite to move again after compliance of the conditions laid down in the order. That was not the order of the Honorable Supreme Court. On 11 December 2008, Stage 1 approval was granted by MOEF in respect of forest land, measuring 660 hectares of Lanjigarh bauxite mine, subject to fulfillment of 21 conditions. Rather, on 18th February 2009, in compliance with the order dated 23rd November 2007, Honorable Supreme Court, JV agreement was executed between OMC and Sterlite India Limited to form a JV company to operate Lanjigarh mines. Clause 2 of the agreement provided that the said JV agreement was subject to obtaining necessary approvals for working the mining lease for the Lanjigarh bauxite mine. This, my Lord, kindly turn to page 35 of the. So this only refers to Lanjigarh mines. Kindly turn to page 35. I did not only page 35 of the compilation.
The agreement starts from page 51.
No, it starts at page 31.
Relevant is 31.
The relevant portion is page 35. And whereas clause 7, I'm reading at page 35. And whereas clause 7 of the agreement dated 5th October 2004, which I led to my Lord, permitted Vedanta to assign the rights and obligations under the said agreement to any company only with the approval of OMC and Government of Orissa, and WAL has accordingly assigned the bauxite mining in favor of Sterlite. And whereas OMC and Government of Orissa have agreed for the substitution of Vedanta with Sterlite in the agreement date 5th October 2004, but bauxite mining at Lanjigarh on the same terms and conditions, etc., etc. Next is very important. And whereas it is also the intention of the parties that the bauxite mined by the JVC, kindly see who was to do the mining, not that price which was fixed, which I read to my lord earlier, the price at which it was to be supplied, that mining was to be done by the JVC. It was the ore which was mined by that JVC which was to be supplied at that cost, which my lord could never materialize. So my lord, today to say on the basis of promissory estoppel, they supply me at that price. Well, I'm reading for that purpose. This mining was to be done by the JVC. My lord.
You wanted to highlight that whatever the promise which was made,
My lord.
which will be JVC.
My lord.
And still the JVC never happened.
My lord.
And the meantime, the has or the
My lord.
has gone a sea change.
My lord.
Where the position has become diametrically opposite to
My
what
lord.
it is to the earlier.
I am ready to
That even
My lord.
this obligation
My lord.
cannot be imposed upon the OMC
My lord.
because this obligation was of a JVC.
My lord.
Maybe the OMC was one of the constituent there.
My lord. My lord.
I understood this.
My lord. My lord.
Only goes to mines.
Specific mines. Specific mines, of course, we have said. And then, and whereas, I have read that already, shall be sold on so and so, so, and now therefore this by agreement lots provides the under. But kindly, my friend want me to read the serial number 1 and 2. Now, therefore, in consideration of the foregoing and respective covenants set forth in the agreement and intending to legally bound by thereby, parties agree as follows. In order to operate Lanjigarh mines, OMC and SAIL agreed to set up a joint venture company. Subject to obtaining necessary approvals for working the mining lease for Lanjigarh mines, OMC and SAIL agreed to enter into the following definitive agreements. So, this is again what the agreements are mentioned.
That's the
Shareholding.
citation of what has been done.
My lord. My lord.
Earlier MOU.
My lord. My lord. But only Roman 4, if my lord want to see at page 36. The pricing mechanism for sale supply of bauxite mine from Nyamgiri bauxite mines as stipulated in the long-term sale agreement dated 5th October 2004 may be changed, reviewed under the orders of the Honorable Supreme Court and laid down in para 8 of the order date so and so. So this, I think I'm done with this. Kindly go back to the list of dates. Serial number 11 at page 4. MU date 4/4/2007 expired by efflux of time.
Say that eventuality as contemplated never happened.
My lord.
So it expired.
My lord. My lord.
Yes.
Serial number 11.
Next point for the one page.
But I will not complete the list of dates and I'll come to my submissions. Sir.
This is on the question of an obligation.
My lord, sir.
But it is an obligation of the JVC
My lord.
or DBA.
My lord.
Never an obligation
My lord.
of the OM.
My lord. My lord.
This is what really you wanted.
My lord.
Second point is another point.
My lord. But their main argument of promissory estoppel cannot be enforced against law.
I do not want to disrupt you because of that.
My lord. My lord. I'm sorry, my
So
lord.
if one point you come,
My lord.
then we can start with another.
I got on it. We do that.
That is what I just.
I'm yet to know. But that is the point which I wanted to make. My lord.
Yes.
Maybe we should have been here.
No.
And I was in the list of dates at page 4.
Serial number 11, you.
My lord, serial number 11. My endeavor was for placing the list of dates. My endeavor, my lord, is to show that all possible steps were taken by Government of Orissa as well as OMC to obtain the mining lease.
So you wanted to take the advantage of are you aiming at the frustration of a contract?
My contract became frustrated because my lord was seen or the intervention of law. The mining lease could not be granted. Mining lease, in spite of best efforts of Government of Orissa, OMP and Vedanta, all three, not that they did not, they also tried their best up to Supreme Court. We also tried. We could not get the mining lease. This JV agreement became possible to perform because of the intervention of the MDR Act Amendment, Section 17. So there cannot be any promissory estoppel against law is my submission.
No.
And with
Agreement
documentation-
are there. That's why I was thinking that shelter under Section 56 of the Contract
My lord,
Act.
sir.
You are trying.
My lord, sir.
Yes.
That is not the point. I will not place the judgments also on that, only one or two judgments. But there are judgments on that, my lords are aware. I'll place one or two judgments to that.
The English, the whole concept is
against law.
whole concept is a Taylor versus called words.
My lords.
The first concept.
My lords. So my friend's submission wrote that you were ready for pillar to post. No, we made all possible.
More spinning mills. I think that is also Supreme Court.
My lord, sir. My lord, sir. Well, actually, I have made a compilation of all judgments with my friend had cited. I'll place it and I'll read only one of the judgments.
Sorry, a little digression.
My lord.
I was just thinking
My lord.
anyhow.
Let me continue. About 11, I had read that the MOU expired by efforts of time as per clause 2 of the MOU after lapse of 2 years from the date of signing of the MOU in the absence of any extension. On 28th April 2009, the MOU granted environment clearance in respect of 672 hectares of Lanjiga, bauxite mine subject to grant of forest clearance, subject specific condition number 3 of the clearance provided for forest clearance to be obtained before commencing mining operations. But that is, I referred the page, I need not.
No, you have.
Grant of environment 2009, grant of environment clearance by MOEF was challenged by several local tribals as well as one social activist before National Environment and Appellate Authority Act 1997 under Section 4 of the NEA Act by filing appeal number so and so. Kindly turn over the page. NEA allowed the appeals and remitted the matter to MOEF to revisit the grant of environment clearance dated so and so by MOEF. By 24th August 2010, proposal of OMC for stage 2 approval in respect to Lanjigarh bauxite mine was rejected by the MOEF. But that is page 48-49 of the this convenience compilation. All page references are to convenience compilation unless otherwise indicated. I need not bother my lord with that. Now, on 30th August 2010, order dated 24th August 2010, rejecting the second stage 2 proposal of Lanjigarh bauxite mine was communicated by MOEF to Government of Orissa. 2011, this is important. OMC challenged the order dated 24/8/2010 of MOEF in rejecting grant of stage 2 clearance by filing writ petition civil number so and so before Honorable Supreme Court. 11/7/2011, by the order dated so and so, MOEF withdrew the environmental clearance granted on 28th April 2009 in favor of OMC in respect to Lanjigarh bauxite mine. 2011, OMC filed IA in writ petition 180 of 2011, challenging order dated by 11/7/2011 of the Ministry of Environment and Forest in withdrawing the EC. The same writ which we had filed, we filed another.
Obviously.
18/4/2013, writ petition civil 180 of 2011 filed by OMC was disposed of by Honorable Supreme Court with the direction to place the matter before Gram Sabha with notice to Ministry of Tribal Affairs, Government of India of para 60 of the judgment is relevant. Can my lord read para 60, my lords, permit me?
This is the judgment, this is Mr. Singh, this is that order in another writ petition where the Gram Sabha meeting, this is that order.
Yes, so ultimately the Supreme Court gave us liberty to challenge this order also.
No. There was another matter you were moving in that the Gram Sabha hearing was not done, public hearing or
No,
something.
it is not this one, that one.
Public here. No, that's a different.
It's not related to this. Okay, yes.
That's a different mind.
Yes. 60, my lord, we only see in the compilation. At page 63, I think.
No, anyhow, this order was directed that there should be before the Gram Sabha.
My lord.
Then matter was placed before the Gram Sabha.
My lord.
Gram Sabha, yes, rejected the proposal.
But thereafter it was rejected by the Gram Sabha.
Yes, then
My lords, on 8 January 2014, in view of rejection proposal by Gram Sabha for mining Lanjiyot bauxite mine, by order dated 8/1/2014, MOEF rejected the proposal for grant of stage 2 approval in respect to Lanjiyot bauxite mine for the second time.
True.
When the second time was rejected, then can you turn over the page? Government of 23. Government of Orissa published long-term linkage policy. Well, this is after all this happened, the government of Orissa published long-term linkage policy in respect to iron and chromite ore. Kindly mark this. For state-based industries through OMC Limited for sustained supply of raw materials over a period of 5 years, extendable to further period of 5 years. Note this, I will only notice that bauxite was not included in this policy because till then we did not have any bauxite mining lease. Only used for iron and chromite and other minerals, excluding bauxite. On 12 January 2015, by way of MMDR Amendment Act, Section 10A2C and 17(2)B were inserted by the MMDR Act, by the Amendment Act. Section 2A, there was right of existing concession holders and applicants. Then we wrote the 10A2C, where central government has communicated previous approval as required under subsection 1 of section 5 of grant of a mining lease, or if a letter of intent has been issued by state government to grant a mining lease before the commencement of mines and minerals, the mining lease shall be granted subject to fulfillment of conditions of the previous approval or of the letter of intent within a period of 2 years from the date of commencement of the said act.
So that was there.
The period when the limit was applied after 2 years cannot be granted. Whatever permission be granted, leave must be granted within 2 years, otherwise it cannot be granted thereafter. The limit was put. When you turn over the page, then note 17(2)B of the MMDR Act, which is important, by virtue of which the JV agreement became impossible of performance, where the government company or corporation is desirous of carrying out the prospecting operations or mining operations.
Just the reverse situation.
My lord.
That you must have a dominant shareholding and
My lord. It was reversed. My lord is right.
Yes.
It was reversed that from 74 of the private company to 74 of the government company. And 26 for the private sector.
And with particular selection process.
Number 20th February 2015, show cause notice issued by OMC to Vedanta as to why agreement dated 5/10/2004 and 18/2009.
True.
No, only not one thing I want to kindly notice in this. I'm sorry, I should have pointed out that 17(2)B amendment. That not the joint venture partner shall be selected through a competitive process.
True.
That also was there. That was also the addition. Besides the shareholding pattern, this also was the addition that has to be by competitive process. Then 20th February 2015, show cause notice was issued by OMC to Vedanta as to why agreement dated to so and so shall not be terminated. Then no reply was given by them, but I did not bother my lord. They were requested to come for a discussion. Then we kindly turn on to page 8.
For the reply, then 29.
My lords. The Chief Secretary Government of Orissa requested MOEF to clarify as to whether forest diversion proposal of OMC for diversion of 660, serial number 29.
Oh, yes, I am reading that.
For diversion of 660.79.
There is a revisit.
My lords.
Revisit.
My lords.
Yes.
But what was inquired was that it can be revived from stage 1.
Oh, that is true.
Whether fresh proposal has to be given.
So revisitation, whether stage 1, stage 2, whether it can be done.
We can revive it or the fresh proposal has to be given.
Correct.
On 29th, 30th September 2015, and this is very, very important, agreements dated 5/10/2004 and 18/2009. Those joint venture
Then
agreements
for the first time terminated.
were validly terminated by OMC after giving a positive hearing to the petitioner and also after obtaining necessary approval from Government of Odisha. By terminating JV agreement dated so and so, it was clarified that supply of bauxite to the refinery would be in accordance with the long-term linkage policy formulated by the government.
True.
This was a termination letter. May I just refer to it at page 70 of the compilation. The letter is at page 70 of the compilation.
70.
No, 70, page 70 of the compilation.
Yes.
29, 30 September 2015, subject termination of joint venture agreement, dated 18th February 2009.
What, 70? 70?
70, I'm sorry. Page 70 of the comparison. My Lord, got it?
Still struggling to get it.
Actually, because
I do not mind 70 here.
But I'm very sorry. I passed another copy.
No, I got it. Yes.
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 That's 29, 30 September 2015.
Yes.
Termination of the subject is addressed to Sterlite and Vedanta. Termination of joint venture agreement dated so and so between Orissa Mining Corporation and Sterlite Industries Limited, Vedanta Aluminium. This is a reference to show cause noted dated so and so for termination of JV agreement dated so and so. Your reply dated to the notice, subsequent discussions held with representatives of Sterlite and Vedanta, namely so and so, etc. In terms of clause 2.3.3F of the JV agreement, and your letter dated so and so. In your reply dated, you have admitted.
So two things. One is that you have put all the efforts. You could not get this particular mine in your favor. Is not there. Now, subsequently, the change has also come, where the shareholding patterns has been just reversed. So, in that event, you say that it is stable. Both the grounds.
And what the last paragraph, what I have pointed out in the list of dates, that supply of bauxite will be in accordance with the long-term linkage policy.
Yes.
That you have noticed that all the efforts that we have made in 17 years have expired. When my lord will notice. So, not at this stage, if you just only make one submission, that my friend's argument that my lord, the obligation to supply continues. It is contrary to all these agreements being terms of the agreement. Not if the agreement itself became void, the obligation to supply. MOUs not came to an end by virtue of the expiry of flux of time. The JV agreement had to terminate because of the provisions of the MMBR Act amendment. So, the question of the obligation to supply continuing thereafter does not arise. This is my respectful submission. The supply of bauxite shall be as per the long-term linkage policies. And JV agreements are terminated and steps may be taken for binding of JV company. My friends want me to read this. Let me just read, my lord, not open it. That letter, the last two paras said, the supply of bauxite to refinery would be in accordance with the long-term linkage policy that I had mentioned. Since the JV agreement stand terminated, steps may be taken to for binding of the JV company formed pursuant to the JV agreement. Yes. Then, my lord, may kindly go to page 9. So, there was no assurance thereafter for supply of 150 metric tons of this bauxite or the price at which it will be supplied. It was said that it was verified, it will be as per the linkage policy of the government. And we had no other mine at that time. But now also not only on the part of information, but we have only one bauxite mine. Where from which, Mullah, I think the capacity is 3 lakh metric tons. With 3 lakh metric tons per annum. Out of which we are giving 2.64 lakh per annum. How much? But we are giving substantial quantity to Vedanta only.
20%.
As per the linkage policy from time to time. 70% we are not giving to them. 30% is by auction and 70% is given to the long term. Whomsoever we have a long term linkage agreement, we give 70%. And the rest is by auction. They can also participate in the auction. Then what 2016. At page 9, in the notification I have referred to the termination, there was no commitment by government of India for supply of 150 million tons or the price as per pricing mechanism that prescribed in JV agreements. Vedanta never, this is important, Vedanta never objected, but this might not be kindly marked in the list of date page 9. Vedanta never objected to notification dated 17/10/2015 of Government of Orissa, wherein it was stated by Government of Orissa that Vedanta is now left without any assured source of raw material supply. Vedanta could have objected, stating that quantity of 150 million tons and pricing mechanism 4 and 9 are in force and have not been terminated. After a lapse of nearly about 11 years, Vedanta is now stopped from taking the stand that 4 and 9 JV agreements have not been fully terminated, and there is only a partial termination of JV agreements, that is mining in Lanchighat or Karlapat or any other substitute mine by JV company, but obligation to supply continues. But that is the solution. At that time, this stand was never taken. It's only now, after 11 years, after this amendment, three writ petition, no stand taken. In this fourth writ petition, by amendment, this stand has been not brought in. 2016, number 32. Decision dated 30th July 13 of Gram Sabha rejecting the proposal for mining was challenged before Honorable Supreme Court by State of Orissa by filing IA number so and so and petition number so and so. The state government challenged that order of the Gram Sabha rejecting the proposal. 20 January 16 pursuant to letter dated so and so of Chief Secretary Government of Orissa, clarification was received from MOE. This my lord will remember. We had asked them whether we have to apply.
Stage 1 or stage 2, remember. Yes.
So it is not possible for MOE to revive the old proposal, which has since been rejected pursuant to judgment of Honorable Supreme Court. And a fresh proposal for diversion will have to be made to MOEF containing salient features as to how the fresh diversion proposal, which will be submitted by OMC, will be different from the proposal which was moved by OMC in 2005. Then 6516. This letter is at page 73 of the compilation. And may I just place the relevant portions? It is page 72, 73. Sir, I'm sorry, page 73. Page 73. No, I'll only read first para is not relevant, but it is in reference to our letter. The matter has been examined by the Ministry in consultation with the second para, with the Ministry of Law and Justice. The advice of the Learned Attorney General for India has also been obtained. After careful consideration of the matter and on the basis of the advice of the Learned Attorney General, I am directed to say as below. It is not possible for the Ministry to revive the old proposal which has since been rejected pursuant to judgment of Honorable Supreme Court. A fresh proposal for diversion will have to be made by Government of Orissa to this Ministry containing the salient features and the factum as to how it will be different from the proposal which was moved in 2005. The views of the Gram Sabha are currently taken before the stage 1 is issued, in contrast to the earlier position when the views were taken post stage 1 clearance and before grant of stage 2 clearance. Since the Ministry is dealing with the project earlier rejected.
So you say that they say that in view of the judgment of the Supreme Court, now they will move for an independent observer to be appointed, taking care of those tribal people's interests. And thereafter they say under the old, what has gone is gone. New proposal will come under the new guidelines, so we'll have to adhere to it.
My lord can grasp it much faster than yours. much faster than I can read. May I go back to the studio? Serial number 34.
So the application was rejected, filed by the government of Orissa.
My lord.
Liberty was given to approach.
My lord.
Either under the appeal,
My lords.
by appeal under the act or as High Court.
My lords.
Yes, then what happened?
Serial number 34. On Supreme Court rejected, IA filed a state of Orissa with the ability to challenge the decision of Gram Sabha with the consequential decision regarding amendment clearance before the appropriate forum. According several appeals under section 6(2) of Scheduled Tribes and other tribal forest dwellers recognition forest types act were filed by the first subdivisional level committee.
That's true. Then what happened?
My lord, that's what my lord said. Number 35. By operation of law, section 10A2 of MDR Act, the grant order dated 5/10/2004 issued by Government of Orissa in favor of OP number 1 in respect of Lanjigarh bauxite mine lapsed. Because the lease was not granted within the 2 years period. That's how it lapsed. I read the provision to my lords. 36. By way of amendment on 24/2018, by way of amendment,
So first time you extended the bauxite into it.
into the law linkage policy. Dated 79/14, a price mechanism was provided to fix the floor price of bauxite. But this one is page 76 of the compilation. Last para at page 76. Now, therefore, after
This linkage is also, as you said, 70-30.
my lords.
Long-term linkage holders, 70%, 30%, national e-option.
My lord. And weighted average.
Weighted average price arrived therefrom.
My lords. Plus margin. This is laid down at what will my lords.
What I gather is the intention was that first thing is the auction has to be done.
My lords.
Average price is to be ascertained after this.
My lords.
This will be given to this linkage, I think long-term linkage
My lords.
miners
My lords.
at that price.
70% and rest my lords by auction, and this in which also they can participate.
No, the pricing is also very important
My
here.
lords. My lords. That is important. And that is not what was challenged in the earlier three petitions.
Correct.
That also, it will come in due course in this list of dates. When the rule 45 was sought to be applied, I just want to pass on to my lords that where is the comparative statement. I made a comparative statement of the 3 or 4 policies. How there was change from time to time. I just want to pass it on. Kindly pass.
Is it executed from people?
Very good. First is 2014 long-term linkage policy, amendment dated 24/18 long-term linkage of bauxite. This was the changes in the policy from time to time. I thought I'll prepare a comparative statement for my lord's convenience. But the difference really by point number C in the first column.
I have seen. That is the main issues.
My
lord. The modalities of ascertaining the floor price has changed.
And rule 45 which came
was made applicable in the second long term, 2023.
That is what was challenged. I mean, this
and 2023 is
again
silent.
That is deleted. So in the earlier 3 petition challenge was the rule 45 only, application rule 45 for fixing the price.
Yes.
Kindly go back to the list of dates.
Yes.
Notes 37. In terms of the amended LPL policy, OMC published, which is important, OMC published the expression of interest for long-term linkage with OMC by state-based user industries for purchase of bauxite from Coding's Mali bauxite mine. That is the mine we have now. I mean, this is at page 80. You know, it's page 81. This expression of interest was issued. Can you turn to page 80 of the compilation?
That was interest. You wanted that whoever is interested in this long-term linkage policy, they can apply.
My lords. But this was really issued, my lord, in terms of, my lord, the termination.
The order of termination.
My lords.
Yes.
Note page serial number 38. By accepting the condition of termination, let it read so and so that supply of bauxite refinery would be in accordance with long-term linkage policy framed by Government of Orissa as well as Government of Orissa notification dated so and so. Amended policy, LPL policy dated 2024 to 18. Pursuant to expression of interest dated 8/3/2018, issued by the Orissa Mining Corporation, without any objection, Vedanta submitted application to supply bauxite.
Participated.
My lord, that is the submission. Without any protest, they could not participate. They submitted an application for supply of bauxite in terms of the LPL policy. It is at page 86 of the compilation.
So you just wanted to, I understood, you wanted to say that the termination was never objected.
My lord.
Termination remains. And this participation implies that they have impliedly accepted the termination and they have agreed to be a part of this linkage exercise.
My lord.
So they cannot fall back
My lord.
to the original. I understand. That is what you wanted.
I don't need to read this.
No, Saban.
If not permitted, only 86, one paragraph, a few lines I will read it.
No, if you are, no, for your satisfaction, otherwise, no difficulty.
My lord.
Yes, you can place 81.
Only 7 lines I will read, that page 86.
86.
My lord.
Yes.
Sir, as you are aware of the present challenges in the aluminum industry, we would look forward to your continued support for bauxite security of 8 million metric tons per annum for the present Lanjigarh aluminum refinery and request OMC to enter into long-term linkage bauxite supply agreement with Vedanta Limited in line with your notification dated so and so. That inclusion of bauxite into the linkage policy. Vedanta undertakes the additional pay price of such ore as and when discovered by additional e-auction. Vedanta hereby confirms to pay the specified.
They also agreed to a floor price or a weighted price. Understood where we want it.
I will say page 11 of this place now. Serial number 39. 20th April 2018. On the basis of application of Vedanta, long-term linkage sale agreement was executed with Vedanta to for annual sale quantity of 8.82 metric tons of bauxite for a period of 5 years. Kindly note if I not turn to page 87.
You wanted to say two things. Was the price is also accepted under the agreement and the duration is also accepted.
And there are the agreements also entered into that.
That's agreement. You wanted to highlight that clauses.
Yes,
I believe so.
My lord.
Sorry to interrupt.
No, my lord, you are absolutely correct. My lord can force you what I am not going to not say. Because this was submission, this is superstition of all earlier commitments. That is what my lord also said. That's our stand.
That clause is applied for page.
No, I don't think that was my lord have understood. I will. The page number is mentioned here, so my lord not have a look.
Yes.
There. Then Lord's serial number 40. No, only one para. I will read. No, my friends are insisting I must read one para at page 95, which perhaps is also relevant. I should have read it. Lord's all page 95. The first para. All discussion and
yes, you say you wanted to highlight that it superseded all the earlier agreement.
So that is Then Lords, serial number 40. 3 national e-auctions for sale of bauxite were held as per LPL policy dated so and so, as amended on so and so. 20 September 19, by virtue of notification dated 20 September 19, Government of India substitute Rule 45(1) of Minerals by way of amendment by Mineral Concession Rules. By way of amendment, by the said amendment, Government of India provided a mechanism to arrive at the average sale price of metallurgical grade of bauxite. Not the challenge at that time was that only for a particular purpose, for the grant of the concession and not fixing the price for sale. That is one of the challenge which was come in subsequent days. October 2019, in view of the amendment of Rule 45(1) of the MC Rule 16, with effect from 20th September 19, fourth national e-auction scheduled to be held in the month of October could not be held, but we sought instructions from the Government of Orissa as to whether we should apply Rule 45 or whether we should go only by this. That is why this auction could not be held. Then 25/10/19, once sought clarification from the state government regarding fixation of floor price of bauxite for carrying out national e-auction in view of amendment of Rule 45. Then serial number 44, 1/2/2020, state government requested Government of India to revisit amended Rule 45(1), but no response was received. Then kindly turn over the page. 15 March 2020, writ petition civil number, this is the first writ petition which was filed by Vedanta.
Yes.
Was filed with Vedanta to direct OMC to conduct national e-auction for sale of bauxite strictly in accordance with the LTL policy as amended by notification dated 24/2/18.
So you have shown that prayer.
My lord.
Yes.
But next also, Lord, is by way there's the interim order passed, but the first interim order passed by my lords. In the
allowing them 1.9 lakhs metric ton of bauxite to be.
My lords, subject to furnishing undertaking to pay the differential price. So, my lord, this order was, my lord, continued from time to time in different petitions. They have been given undertaking to pay the difference. But 22nd April 2020, IL number so and so, a similar order was passed by my lords on the similar undertaking. I will read it bother my lords. Then, lords, on 19/8/2020, serial number 48, after several correspondences, state government clarified that OMC shall conduct national e-auction as per LTL policy, calculating average sale price in accordance with amended Rule 45 of MC Rule 2016.
Yes.
This is state government clarification.
Correct.
But that's it, page 9, page 100.
No, I understand. This is for the first time because they did not in the meantime in the meantime one writ petition came or intervened.
My lord. Then lords, on 24th August 2018, fourth national e-auction notice for sale of bauxite issued by OMC on the basis of the clarification issued by the state government. Then 3/9/2020, another writ petition was filed by Vedanta challenging national e-auction date notice date 24/8/2020. That prayer had led to my lord, prayer was in regard to the Rule 45. That is why I have given the page number here. Can you turn over to page 13, serial number 51. In writ petition civil number 22397.
No, in this petition, 1,000 rupees per metric ton of bauxite.
My lord.
Interim order was passed. Where they challenged this auction.
My lord.
Is that?
Then, 8th March 21, one petition was filed by Balco. Apart from other challenges, validity of letter dated so issued by a passport number to Government of Orissa, as well as constitutional validity of Rule 45, as amended by notification dated so and so, were also challenged in the petition of Balco.
So, in the workability, to support the workability of that.
Lord 53, my lord, writ petition 10280 was filed by Vedanta challenging constitutional validity of Rule 45 as amended by notification dated so and so. The demand notice raised by OMC on the so and so floor price of so and so as per Rule 45. Then, Lord, 18th March 21, writ petition, my lord, number 926 was withdrawn.
First one.
My lord, that is the first writ petition which is withdrawn.
Yes.
In the subsequent developments, reserving the argument to advance in the other 10280. 18 March 21, writ petition 22397 was filed by Vedanta was disposed of as withdrawn in view of subsequent development, reserving these
So they withdrew both the rate.
and brought reserve the right to
Correct.
submission the 10280. Not on 18th March 21, rate petition civil 10280 was disposed of, filed by Vedanta was disposed of. In order dated 18th March 21, case number is only mentioned that only just for information. Can you turn over the page? 28th March 21. MMDR Act was amended by MMDR Amendment Act 21. Clause D was inserted after Section 10A2C of MMDR Act. Newly inserted Clause D reads as follows. In case where right to obtain license or lease has lapsed under Clause B and C, such area shall be put up for auction as per provision of this Act. My Lord, this is further amendment to Section 2. And now this is as per the auction as per the Act. Then Lord 7421, in IA number 5392 filed by OMC in so and so, this Honorable Court recalled order dated 18th March 21 and restored WPC 10280 as an interim measure. Honorable Court directed OMC to permit Vedanta to lift the agreed quantity of bauxite for remaining period of 21-22 from its yard.
No, why?
No, this was perhaps because not in the earlier order, not there was no this given for the past dues, undertaking for the past dues in the earlier order.
Okay.
So that's why perhaps this IA was filed. Then not here, my Lord may kindly not only know, add two dates. I'm sorry, I should have included it. 30th August 2021. Can you just add those two dates? Well, I will not give fresh list of dates. But 30th April 2001, counter evidence is filed by Government of India in writ petition number 9358 of 21 in the Balco case. So this what I want to show is the stand taken by my Lord Balco or by Union of India in that Balco writ petition with regard to Rule 45. Can you now turn to page 152 of the compilation? Paragraph 25-26. Page 152 of the compilation. Page 152 of the compilation is the counter affidavit filed by Lord Union of India in the Balco writ petition.
Page.
The relevant portion is at page 155 and 156. Only two paragraphs, 25-26.
That's from page 150.
Yes, we have only given the relevant exactly. Paragraph 25, page 155. That in the whole scheme of MMDR Act and the rules framed thereunder, with MCR 2016 auction rules, competition of ASP is prescribed for the purpose of auction of mineral blocks and also used for arriving the royalty for some minerals. In the scheme of rules made under the Act, ASP is employed for arriving at a reserve price, bid security, performance security, and upfront payment. In case of auction of mineral blocks, formula for calculation of ASP is also used for determining royalty of some minerals, while in the case of metallurgical grade bauxite, royalty is calculated on the basis of London Metal Exchange, MMDR Act, and the rules framed therein, and do not prescribe a private use of ASP arrived through the formula under challenge for prescribing the floor.
It was left to the wisdom or the freedom was given to those PSUs.
My lords.
To find out the floor price on the basis of e-auction.
My lords. On the last line at page 155
has not prescribed any guideline to that.
Prescribe or prohibit. What they say is it does not either prescribe or
prohibit. Yes.
It's in the ASP.
Yes.
That through the formula under challenge for prescribing the floor price. It is for the POC concerned, as my lord rightly said, to decide the methodology for arriving at the floor price of so and so and so and so. So they will not do this. This is the stand which was taken. The next parameter, the auction of mineral blocks for grant of prospecting license, mining lease, composite license, so and so, and national e-auction conducted by OMCL for sale of bauxite are two distinct activities. In case sale of bauxite through e-auction, it is for the merchant seller once you decide the floor price. In the formula of ASP rule, so and so has been used.
So it was again left to you because you applied that formula 45. It says that you justify that why you have applied.
Page 157 is another additional affidavit of the Ministry of Mines, Union of India. In the Balco case, para 13 and 14 only my lord may just notice at page 158. Page 158, para 13 and 14. It is humbly submitted that Orissa Mining Corporation conducts auction for mercantile sale of bauxite mineral and not auction of mineral blocks as stated here above. So, when auction of mineral blocks for grant of minerals and so on and so and so is conducted by OMCL for pay so and so are two distinct activities. The sale of bauxite to the auction for the merchant to decide the floor price. The ASP forms integral part of the grant of mineral concession, including realization royalty. HON'BLE for calculating ASP is bauxite.
It says that if they have applied, they have applied. That does not mean that the entire rule would be declared as ultra virus.
That's it. No, they say it's up to them to follow or not to follow that rule. It's open to them to decide. I kindly will come back to my page serial number 59 of the list of dates. 6/4/22. Again, another interim order was passed on furnishing the undertaking as you learned before. Can you turn to page 15, my lords? But then another policy will also come by the government, which I have not put in that comparative statement. LTL policy dated 17/14 with all of superseded by LTL policy dated 16/8/22 of the state government. Then notes 25/1/23, it petition was filed by Vedanta and by Balco, but disposed
of representation.
My lords. Then pursuant to the order, the representative submitted by Vedanta to OMC, petitioner submitted.
Balco did not submit.
My lords. Then note, serial number 65, IA was filed by Vedanta for revival of the petition 10280 and for modification, clarification of the order.
Which was rejected by this court. Then
it was rejected on 16th March 23.
Then the present
my lords
is filed.
My lords. But they automatically filed the IA for revival of the writ petition, which was dismissed.
That was rejected. Then the outcome of that rejection is the present writ petition.
My lord, fine. My lord. That is not how on the next page that's what we mentioned. Page 66, my lord have already noticed that they filed the present petition as the outcome after the murder direction of the representation. In this also, my lord only not I have noticed that the pair only not challenged Rule 45. The present pairs were not there regarding promissory estoppel, etc. 29th March 23, in IA number so and so, this honorable permitted was again brought an order was passed regarding lifting the bauxite. Took the subject payment of 1,000 rupees and giving an undertaking.
Yes.
Then Lord 19/4/23 LTL sales agreement was executed by Vedanta as per amended LTL policy that came to an end by lapse of time. With the LTL agreement of 20th April 18, which was not signed by them, was not for 5 years. So that came to an end by lapse of time. 15/5/23 in writ petition 96, this honorable could observe that unless Vedanta executes fresh agreement is important. In writ petition 917 that the present writ petition, this honorable court observes that unless Vedanta executes fresh agreement with OMC,
this interim arrangement is not workable actually.
My lords.
Then
lords 16th May 27, application Vedanta fresh LTL agreement was executed. As per LTL policy of 622, annual allotted quantity is 24 lakh metric tons. And per allotment, per quarter allotment of 6 lakh metric tons. That was not the under this agreement, the allotment. Total 64 lakhs and per quarter 6 lakhs empty.
Yes.
Was to be supplied. 19th May 23, in I number so and so and so, court directed interim management to continue. That matter is not relevant. Kindly turn over the page. Then the LTL policy with all its amendment was superseded by another policy 23 that my lord has seen in that comparative statement. Number 73, in 11th National E-Auction Notice, one pioneer aluminium industry participated and quoted the amount of 2480 per MT of bauxite against floor price of 2470. Accordingly, auction was settled in favor of pioneer. Such settlement was subsequently cancelled because consent to operate was a conditional one. Then 13th auction was auction notice issued to settle in favor of pioneer for 2967. That content confirmation was issued. So what we try to show is that we could get this.
Yes, you wanted to say that as per the rules which are there, the floor price or a wheat average price, whatever, is to be ascertained on the basis of a price which you obtained in an e-auction. And this is what you wanted to say, that we received the price in the e-auction in this way.
That is my submission. Then Lord Pioneer Avenue made the point, etc. And my Lord, the already understood, I don't need to bother. Can you turn on to page 18? Then we have referred to various e-auctions.
Yes.
Then Lord, the last Lord, on that page, the bidding sale price was 3009.
Correct.
Then kindly then next page, my Lord, will see the price, various price we have given for the various auctions, 3128, 31117, 2820, 3037, etc. So all these prices have been, the bids have been received, and which will have been acted upon by the various bidders, which they have been accepted. Then sometimes no bidder also came forward, that also we have mentioned. Then now not 10/11/25. In course of the hearing of the petition, on the basis of submission made by the petitioner, this Honorable Court permitted the petitioner to take out an applicable amendment. In I number so and so was for amendment was filed. Then not
objection made.
My Lord, they have no the history, my Lord. I don't need to bother.
Yes.
My serial number 96 is a little important. By order of 3rd December 2025. IA number 20687 filed.
Understood. This was the prayers were allowed. Yes. Yes.
Only prayer A was allowed, Lord.
Yes. Yes.
Prayer B was not allowed. That is
yes.
Not. Okay, that was not regarding pleadings and additional documents was not allowed. But my Lord, my Lord already observed during the hearing when my Lord allowed the amendment that you filed, that whatever pleading already there, you can raise grounds. That is what my Lord did. That's how my Lord allowed in that. On those terms only. Then Lord's OMC filed the additional counter to the amended petition. Vedanta filed rejoinder to the additional counter dated so and so. But this is a little important, but this is how we filed the expansion application. Additional filed rejoinder to the additional counter affidavit dated so and so, incorporating the pleadings as well as documents. They are part of IA number so and so, and were not allowed to be taken on record by this Honorable Court by order dated so and so. Even the specific prayer was made in the respect by the petitioner as prayer B. So that is the. My Lord, only record my submission that my friend the other day pointed out that we also took objection to certain orders of the Supreme Court or some notifications not being taken on record, but I will not press that. I will not withdraw that. If we have made such a submission, it's only the pleadings.
Is a whose choice and whose initiative.
So whatever it is, I take responsibility. Then it's only now the pleadings which were included.
No, I got your point.
My Lord. And the other documents, not notifications or orders. I will never be party to such to objecting to those being taken on record. Then Lord, 9th March 26, I filed a rejection expulsion of so and so. My Lord said that we hear it wrong with the petition. But that is the long and short of the facts of the case. I now not come to submissions. But my first submission is that as well as my Lord also are well aware that my Lord it is a settled legal position that my Lord the doctrine of promissory estoppel cannot may not be availed against the law. But in the present case, the obligation of the under the MOUs of 7/6/2003 and 2007 with regard to grant of bauxite mining lease could not be implemented in the absence of environmental clearance and not the forest clearance, in spite of all possible efforts of all three parties, Government of Orissa, OMC and Vedanta, up to Supreme Court. And those last they were for 2 years each, but last
by flux of time.
By flux of time. The last flux of time, and also could not be implemented because of the various orders of the Government of India rejecting the applications and Honorable Supreme Court not accepting our submissions and not granting allowing the grant of the forest clearance and the environmental clearance. But the MOU dated 7/6/2003 clearly providing clause D that in the event of non-implemented project, a part thereof corresponding support obligation. I had read that to my lords. Corresponding support obligation of the government in the MOU with regard to bauxite ore mines, incentive concession of the government shall be deemed to be withdrawn. That I had read to my lords. Then both the MOUs expired in 2009. JV agreement dated 5/10/2004 and 18/2/2009, which provided for raising of ore by JVC. And long-term purchase agreement became unimplementable by virtue of section 17A 2B that my lord said that shareholding pattern. So all the MOUs as well as JV agreement became non-implementable by virtue of operation of law and the various orders of the Honorable Supreme Court. So there is no case of any promissory estoppel not being invoked against the OMC or the state of Orissa in view of those. Only I'll pass on. I will only read those two paras of those two judgments, which my friend has actually cited. I have not made a compilation of all the judgments which my friend has cited. I am only referring to those two judgments out of those. So it's a little bulky, my lord may not mind, but I have made all the judgments which my friend had. But I will only refer to those 2 or 3 pages, nothing else. 2 or 3 paras from each judgment. Page 61, with a Modilal Kadampar. Page 61. Sorry, compilation. Running page 61. Where it starts at 61, then it goes up to 107, para 27-28 at page 98-99. Page 98-99.
Para 20.
27-28. At page 98, note the before para 28, the last 10 lines. Last 10 lines before para 28. Lastly, a proper reading of the observations of the court clearly shows that what the court intended to say was that where government owes a duty to the public to act differently, promissory estoppel cannot be invoked to prevent the government from doing so. This proposition is unexceptionable because where the government owes a duty to the public to act in a particular manner, and here obviously duty means the course of conduct enjoined by law. The doctrine of promissory estoppel cannot be invoked for preventing the government from acting in discharge of this duty under law. Doctrine of promissory estoppel cannot be applied in teeth of an obligation or liability imposed by law.
True.
Then 28. We may then refer to decision of this court in assistant to a custody so and so. It is not necessary to reproduce the facts of the case because the only purpose for which this decision was relied upon under the state was that the view taken by the House of Lords in so and so was preferred by this court to that was taken by Lord Denning in so and so. It is true that in this case, the court expressed the opinion that the view taken by the House of Lords is the correct one, and not the one taken by Lord Denning, but we failed to see how that can possibly help the argument of the state. The House of Lords did not, in Howell's case, negate the applicability of the doctrine of promissory estoppel against the government. What it laid down was merely this, namely that no representation or promise made by an officer can preclude the government from enforcing a statutory prohibition. The doctrine of promissory estoppel cannot be availed to permit or condone a breach of the law. The ratio of decision was successfully put by Lord Norman when he said, neither a minister nor a subordinate officer of the crown, nor any conduct or representation of the crown from enforcing a statutory prohibition or entitled.
No, there is no difficulty. If there is a prohibition, it cannot go. There cannot be a promissory estoppel.
My lord. But then, Lord, the other judgment is page 126. The Godfrey Phillips, same thing was reiterated. Page 126. Page 108. It starts at 108.
10?
It starts at 108. My judgment starts at 108.
Yes.
At page 126, para 13. The bottom of page 126. My lord, what? Page 126 bottom.
Yes.
Last paragraph, so that 13.
Of course.
So we must make clear that it is also laid down in Modilal that there can be no promissory estoppel against the legislature in the exercise of their legislative functions, nor can the government or public authority be debarred by promissory estoppel of enforcing statutory prohibition. It is equally true that promise stopper cannot be used to compel the government or a public authority to carry out representation of promise, which is contrary to law, which was outside the authority of power.
I think it is too fundamental or a first principles.
My lord, I
don't think so. Anybody can contradict it
I have not even
or
done
say anything in this regard.
So the submission, my lord, that the principle of promise stopper cannot be invoked to compel the OMC or state government to act contrary to law. The law not today is what it is. Home Lord, today to say that you supply me at that price, which was never raised earlier, by virtue of promissory estoppel. I have made those submissions, I don't want to repeat. That the MOUs lapsed, the agreement came to an end. The mining was to be done by JVC, which could not happen because the change in the amendment of Section 17. So it became not impossible of performance by operation of law, and we could not get the bauxite mining lease in spite of our best effort. So there is no great promise of being invoked against us. Then the next submission, my lord, is that the conduct of the petitioner after 29th September 2015, as documented by letter dated 30th September 2015, Government of India notification, LTL policy, then Lord's expression of interest, which OMC
and their participation and then entering into an agreement, these are all can be construed as the waiver of their maybe whatever the right which he had, and they have accused to such right, which they cannot resurrect now.
That is the respect to such, my lord. I could not have put it better, my lord. Then the documents and record and conduct of petitioner post so and so reveal that the after terminal JV petitioner agreed to avail the mentioned long-term degree, etc. My lord has rightly said. Having accepted the auction of 30% saleable stock of bauxite for private discovery since February 18 is not open to petition to take the plea in 2026. So there are partial termination of JVAs, and my lord's petition entitled 100% bauxite from the Kodimangli mines. And Lord, then we have sent to prayer A1 and A2 are contrary to prayer C and D.
That does not invalidate the whole of the writ petition to fall.
My lord, sir.
Even if they may have claimed or made several reliefs.
But
if one is, they are entitled, the court can restrict it to one.
What will remain only Rule 45.
Only one principle is that if it is mutually destructive cases have been made out, then a court can definitely see that the dismissal is the possible. But relief, they can claim many things.
Relief, they can claim on the basis of a legal right.
Whatever. Not even a legal enforceable right.
My lord, I stand corrected. My lord is right. My lord, I could not have put it better.
No, that's
legally enforceable.
No doubt about it. What you say is correct.
My lord.
That's there, no doubt.
My lord.
Unless there is a legal right which has accrued to them, which is applicable to them.
My lord.
And that legal right must also be enforceable in law.
My lord.
Otherwise, they cannot.
My lord. That is sorry.
8 para 6.3. 8 para 6.3.
So, my lord, submission note to summarize is that doctrine of promissory estoppel is wholly inapplicable in the present case. MOGM belongs is by terminated. No, I have already said I did not word, so it's only I'm summarizing. Accepting termination, no clear and unequivocal promise subsists. There is no equity in favor of the petitioner since he has accepted all benefits of new contractual agreements. Then, on that, we will rely on certain judgments. I'll pass it on. I don't need to bother my lords now. Then, Lord, the next submission, my lord, is that the MOUs and JV agreements are determinable and cannot be specifically enforced.
That is the Supplementary Relief Act.
That, my lord, is the 14th of February that my lords are aware. So on that, Lord, certain judgments, my lord, I have relied upon, which
Hindustan Petroleum judgment is one of them.
One Indian oil is there.
Indian oil is there. Petroleum, many judgments. Petroleum sectors, many judgments.
My lord.
Terminable contract.
My lord.
Can you tell me just academic discussion. Can there be any contract which is not terminable? I think every contract is
My lord.
susceptible to be
My
terminated.
lord. My lord, that this was my lord. My lord is saying what is said in section 14D is actually
Rule against perpetuity. I was
My
just
lord.
thinking about it.
my lord. Well, I appreciate my compliment.
Every contract agreement is terminable
My lord.
in nature.
So the claim of the petitioner based on promises established is also not barred by limitation as well as delay and lashes our submission because they never raised this on all these years not from 2004, 2009 what this happened. They accepted benefits for subsequent policies, etc. My friend wants me to point out that as it was an order is not been challenged within a period of limitation Marathon's finance. Then my lord goes without saying, my lords, no lords are better than me. Then my lord, now I will come, my lord, straight away to rule 45. So that is the other challenge in the petition.
That is, yes. According to him, it is relatable only or restricted applicability to a captive mines. It cannot hover around.
My lord.
And that is what the central government also said. That if you have applied, it is your wisdom, you justify or do whatever.
My lord.
We are not going to say anything on that. Sorry.
So my lord, submission is my lord. Then the rule does not prohibit its applicability to commercial sale of bauxite. Although, of course, it is not for to calculate the average sale price of this the mineral and not the. But the formula, the submission, my lord, is this: there is nothing stops the state government from adopting that formula. We are not applying Rule 45. Let's assume that we may not apply Rule 45. We are not at Rule 45, but we have put the same formula. Could have done it. Just because we have stated that it is as per Rule 45. Without mentioning Rule 45, the same formula would have been applied for fixing the sale price. So not just because we have borrowed it in this literally, so it will be as per Rule 45. Whereas better reports would have been to only say that this will be the formula, and that formula only could have been put in the policy. So if that could be done, then why not this? We can tomorrow maybe issue another policy, government can issue another policy, only giving that formula. Or maybe with a slight modification. Then section 13, my friend had referred of the MMDR Act. Kindly just have a look at it.
Power to make rules.
My lord. Section 13.
Yes.
The power of central government to make rules. The central government may, by notification in the official gazette, make rules for regulating grant of mineral concession in the state of minerals and for purpose connected therewith. So it is a much larger power. It's also for any purpose connected therewith. So I only wanted to refer to that.
But we get to the judgment. There is for relief.
And not there is a judgment which no not deals with this expression in connection therewith, which I was submit along with my written notice solutions. So the submission is that central government has the power to make rules for purpose connected with my lord's this mineral concessions. In fact, chapter 12 of the MC Rule 16 deals with minerals valuation and really provides guidelines, principles for determining of sale value, payment of royalty, competition, average sale price, etc. Also lay down guidelines, principles, determination of sale values. Granted the rules is inextricably linked to the power given to grant concessions. When the power given grant concession is given, but this power to fix the price, all the minerals also interlinked is my submission. With the power to grant concession. That's why the rule is not, rule can provide also for the price of the mineral how it is to be disposed of. The power to grant mineral without any guidelines principles for determination of sale value for disposal of minerals would result in leaving disposal of minerals at the complete discretion of the executive. If no formula is laid down, then we have discretion of the executive. Government, which one has to be not judicially or properly exercised, if that goes without saying.
So according to you, if it is left unregulated,
My lords,
then it will invite
my
a
lords,
lot of
my lords,
you go negative
My
the concept to come,
my lords,
and the uniformity that would be completely shattered.
my lords,
So in order to bring a
my
uniformity
lords,
in all respect,
my lords.
this formula
Please, my lord,
have been a best guiding factor
my lords,
to decide.
my lord, I could not have put it better. But therefore, Article 220 does not permit conversion of commercial contracts dispute into constitutional name of that. Now, lords. Then lords, my lord, the joint affidavit introducing rejected pleadings. Then lord, I will not pass on a comparative statement. So we have made a comparative statement of what was included in the application and was not allowed, which has been introduced in the reply to the our additional counter.
This way.
I will just pass on this. I have made a comparative statement. I have not given the. I have only given para numbers. I have not given the extracts. I can also give the extracts if my lord's desire permit. I will also add the extract. I don't make it too long, so I will only give the para numbers.
No, that's true.
But whatever was asked in whatever was prayed in the application is on the right hand side. I for amendment, and what has been included in the rejoinder is identical. Even though my lord did not allow that prayer, it is submission. So it would be deemed to be rejected once it was not granted is the our special submission.
Which page you can do? Page 4 can be
Not page 4 of that this what I have handed over.
This will
But this I must also not say. This is a comparative chart of documents. So sir, this I want to qualify by saying that if I have objected to any notification or order, I withdraw that objection. With regard to this page 4 of this compilation, if I have objected to anything, which my friend rightly said, I will not. I must be fair. No, that is respectful.
Thank you.
I'm here to my notes.
Not 2-3 days to start with.
But the government perhaps still has to reply, I think.
Oh, there is another. Yes, do you have anything to add more? I think the learned senior counsel has made I would say comprehensive arguments have been already been done, touching upon all the aspect of the matter.
He was supposed to,
because you were also instrumental in many aspects. Anything more to add?
precisely my senior has covered everything, all the aspects of the he wanted to address one on 15.
Why? Whatever is there, they are the PSUs. They are, may I say, not tacit, but a direct control under you.
They work according to the policy framework.
Whatever the instruction that comes from the Department of Mines steel and mines or mines and steel, whatever, that they have to act on that basis. Now, all the facts are there. MOU has been entered into. Everything is on record. He has taken us to various aspects where if I jot it down in a very succinct manner, so there are actually 4 or 5 points. Basically, broadly, he has it. So, what more argument that is advanced?
MOUs were never worked out. The MOUs had a self-life period.
No, that he has argued that it is a period of 2 years which expires by flux of time. It was never renewed. Rather, GVA comes, GVA continued. There were certain obligations. All 3 of you tried to work out, who do not work out. Ultimately, change of law, rendering that particular GV agreement contrary to the law. It has to go. It has gone. Everything he has argued. What more? Even he has gone to that extent at one point of time, this bauxite was not given to them. It came subsequently, only one mine they are operating. Still they are obliging by giving a 70% of the total extraction.
That long-term linkage first time came in 2018.
So linkage, you have done it, linkage policy.
Bauxite was incorporated in 2018.
I know that's the second or a first.
2014 only iron ore and bromide. 2018 bauxite.
The second bauxite. No.
The amendment came in 2019. After 19, the only long-term linkage agreement is of 2022, which they invariably.
You have also renewed, that has been renewed, which is, I think, in 2025, operating or 2024.
The long-term linkage policy that came in 2020.
No, I understand. There were on that which expired.
It will expire in 2028.
28 or 29 is going to expire.
It's going to expire. And 2023, not yet implemented, no agreement has been entered. And only the 22, since they have agreed and entered without any demur, without any.
That he has said.
Yes.
That he has said that without any objections, without anything, so that cannot be done. What more? That he has covered all the arguments.
And union will not say anything. Union will not say anything, I think. Union is also party.
Oh, Union of India is here. Party?
Yes. Slate face.
Yes?
Slate face.
Number 1.
Slate face.
What's who is representing Union of India?
Yes, my lord. May I audible, my lord? Yes.
Yes, both, sir.
Sorry, my lord, because of the another matter is there.
Yes.
In this case, we don't want to file any because we don't have any instructions. Let's start again. Let's start.
Okay. So who is your counterpart here representing Union of India? No documents, nothing. Nobody is appearing along with you.
Yes, Mr. Kashyap is appearing. He's ill. That's why Mr. Maharana is there. He's with me.
Yes, who is here?
Mr. B. Maharana.
This is no, not here.
Not here. He's with me.
He's sitting with him there. He's sitting with him.
Oh. Both on the virtual mode. Okay.
Yes, Mr. Kashyap is absent today. That's why I asked him to.
Yes.
That the land AG wanted to address in line with.
But this matter was fixed much when it was fixed today. I think Mr. Mehta, he was there on a virtual mode. Request was made. It was done when?
Very first of May.
Just imagine. Today is, we are on 12th. 12 days before this matter was fixed today. So,
my notes and judgments all are ready. Only the learned AG will address on 14th at 2 p.m. for 1 hour. My lord, nothing.
Still he will take 1 hour.
May not be more than that, but only to align with the submissions made by the OMC. That is the only submission.
I was very apprehensive when this matter started, that the way the gaps are coming, it's very difficult to keep everything in the mind all the time.
After tomorrow. After tomorrow.
AG has never come in this matter. He came only once to take a date. That's all, to take an adjournment. That too in lieu of Mr. Mehta. And he said, I will argue the matter. The next date again, he has disappeared. I thought it's something I don't want to say anything further, but it's actually not fair on my part. But I think everything that the state could have argued, I think more than that, Mr. Mehta has already argued. But I'm telling your lordship, I can't.
Mr. Das is competent.
Only once he has appeared.
Are you sure that he will appear?
Yes.
On a date fixed.
On 14th at 2 p.m.
If you give an undertaking that you are sure.
That is I'm not. I can't say more than that, Lord. Only thing is not normally.
I think London DSP has taken a very, I would say, fair view in this regard.
Only Lord.
Because efficiently the Union of India has actually no role because it is everything.
Only on the state, yes.
No. The OMC and you.
OMC and us, absolutely. And if a matter is fixed on a date, Lord, councils are supposed to be present. They can't be Lord that you, if matter is fixed and you say, today I'm not available. And your lordships are right on that day also, whether he'll be available, there will be no guarantee.
On 14th, if he doesn't, then I'll apply.
Then you should ask you today itself.
Then I'll ask.
I can assure my friend that my friend.
No, we are present. We are when he has assured, he will definitely be here. It's on the lighter side.
Lord, only thing I'll request that, Lord, if he wants it on the 14th, let it be the morning. I'll tell you, Lordship, why. Because I'll have to rejoin. If the AG takes time, then matter will not finish. So let it be the morning, whatever time he finishes, I'll rejoin after that.
I think all the members of the local are cursing us.
But that happens, Lord, whenever any hearing starts, Lord, in every court, that is a problem. Today, when Sabrimala has started, so many lawyers are in the alternative bench and they remain in the alternative bench for Lord weeks together.
No,
so
what my lord is saying, what my lord is, But my lord is saying I overheard people say.
The murmur from behind.
No, your lordship can start at 12 so that your lordship can finish whatever matters by 12. At least so that we finish this matter. That's all my request, Lord.
When he is there, every matter there is an urgency. Particularly Mr. Tolai's matters are always urgent.
Not a single
matter. I think again that is not urgent. All his matters are urgent. Tomorrow his client will go where he doesn't want nobody knows. So that is what I find. So it's very difficult up to 12
to manage
the issue.
12:30, whatever, Lord, so that at least it starts before lunch so that we can finish it on that day. That's all. Although I'll not take more than half an hour, 45, not more than that. I need to basically answer my friend. I know nothing really new will come from the AG, but still we have to.
Yes, sir.
So that is why I'm not, your lordships are also working only, I believe. We are working.
I am also thinking.